Thanks for joining us for Procurement and Government Contracting Compliance. My name is Raphael Zahardin, and I'm your moderator. This webinar is part of the Financial Boys webinar series, Corporate and Regulatory Compliance. Slide 7 can give you a nice summary of our series. Slide 8 summarizes this episode. I want to thank our sponsor, Mood Hardworking Cannabis. Please read about them and their Type to Learn app on slide 3. Speaking of the slides, you should understand from the get-go, we'll not step through the PowerPoint in order, nor will you have to listen to us read any slides. This webinar, like all Financial Boys webinars, is going to be a conversation. You can keep the PowerPoint handy. It's a wonderful reference. We may touch on it. Some of my panelists may touch on it, but generally speaking, that's not the way these work. So our panelists are Pia Thompson, which is founder and the fractional general counsel at Lawson GC. Alexandra Prime, who's a lawyer at Miller and Chevalier. Habib Alahi, partner at Shartler, Honorati, Mead, and Sears LLP. And as I mentioned before, I'm Raphael Zahardin. I'm a partner at Lewis, Brisbois, Bisgard, and Smith, and I'm also the author of this compliance series. So for better or for worse, you can blame me for the series, or you can send me a nice note about it. We appreciate you're not spending your time and money to hear infomercials about us. We do have bios on slides 46 to 49. We've got a wonderful panel today. I would take a look at them. They're great experts. They've got a great breadth of experience. They have varied practices within the government contracts arena, and we've got perspectives both from both lawyers working from law firms and in-house lawyers. This webinar is a production of Financial Poise. You want to sign up for Financial Poise's great weekly newsletters, go to financialpoise.com, or you can shoot an email to info@financialpoise.com with the word subscribe in the subject line. If you're attending this live, you can submit questions using the web portal. If you have questions after the webinar and you want to get to us, again, just shoot something to info@financialpoise.com. It'll come to us, and include your question, the name of the webinar episode, and we will do our best to get back to you. So with some of that housekeeping out of the way, let's talk a little bit about what we're going to do today. So why is procurement and government contracting compliance important, particularly to a general practitioner or somebody who's in-house counsel? Well, there's a volume and complexity of transactions that are related to procurement. Both state and federal regulatory compliance is really tough to navigate, and it can make even routine sales and marketing practices vulnerable to both civil and criminal liability. So we're going to take a look at the regulatory framework. We're going to identify some of the legal risks in solicitations, what happens pre and post award bid, and also contract compliance, change orders, and also contract claims and disputes. So we're going to try to cover it from nascency to end game. The webinar also discusses defense strategies of a company that's accused of fraud or civil noncompliance, which can become an issue. Compliance is going to hit pretty much all aspects of a company's life, and the market for government contracts is significant. The Department of Defense was the largest government purchasing agency in the last fiscal year, everything from aircraft components to vehicles to electronic equipment. Its procurement spend is well over $100 billion based on just the public data. But all government agencies, both federal and state, generally engage in procurement, both for products and services. And there's also a great deal of subcontracting that goes on across all sectors when you see procurement activity. So kind of against that landscape, and after doing the introductions, Pia, I'd like to ask, generally speaking, what are the areas of compliance that involve procurement and dealing with the government?
Sure. So hello, everyone. Thank you for joining. The overriding thing in areas of compliance come in the bucket called governance. And so that word gets thrown around a lot. It is all encompassing. And I'll get to the specifics of governance and why that could, really streamline and make your chances of success and your efficiency in multiple procurement RFPs worthwhile. So the first one, I'm not going to go into any detail on it, is government contracting regulations, right? So that's a basic. And the other thing to remember about this is it doesn't necessarily need to be your legal department. A lot of times you have procurement professionals in your organization, or you want to look for those kind of people to bring them on board because they're like other folks in the space. They know it better than anyone else could know it. I think of it as a HR manager, right? They really get what's going on. So let's now go right to things that are obviously governance. So your procurement compliance practices, right? So you need to be able to show the money that's coming in is being spent for whatever the contract is for, that you have tight controls on that you've got, that's one of the overriding things. The things to also think about that, right, are the different types of procurement and what are the rules around that. And one of the things I want to highlight with that is these contracts aren't always directly with the government. So for example, in the renewable energy space, the giant utilities, Exelon, some of PG&E, some of the other ones, have these targets for renewable energy, and they can't supply it. So what happens is the Department of Energy does a huge grant, and then these private entities contract with folks to fulfill these government requirements, and they're using government money for it. So all of these itty bitty solar, wind, water, whatever they are, need to be prepared to satisfy all the big government requirements. And so you really want to think about not having to recreate the wheel every time. And, because you want to be able, as a smaller company, to get as many bites at the apple for that. And so it goes to your compliance checklists. Make sure, again, all goes back to governance, but the more you have kind of institutionalized, for lack of a better phrase, it's going to be better. And as part of your compliance checklist, you want to be able to demonstrate your risk management. And that's not risk of violating regulations, because that kind of goes with the territory. It's really being able to demonstrate in an enterprise risk management framework. And again, there are, that is good for your legal department. And there are lots of lawyers who are governance, risk, and compliance professionals. And you'll want to leverage that because those frameworks exist. So you shouldn't have to be doing that as well. And then we'll talk about this later, but confidential information on cybersecurity is at the top of the list for the government. And no matter what area within which you're contracting, that has to be robust and tested and demonstrated, documented. There you go.
Great. Thank you. Alexandra, tell me what drives compliance in government procurement, and is it different from private procurement issues that come up?
Yeah, sure. And I want to reiterate, thanks for having me today. I'm excited to be here talking to you about public procurement. So yes, the answer is public procurement is very different from private procurement practices. Really what drives the process of public procurement, federal public procurement especially, is a mix of legal and regulatory requirements, but also public policy considerations, and most importantly for most businesses, good business practices. So in these types of public procurement contracts, the terms heavily favor the government because the government is a sovereign entity. It's the ruling power, so to say. It has rights that commercial businesses just don't have or can't get away with in private procurements. For example, one of those rights is the government has the unilateral right to revise a contract or to cancel a contract, as long as it's within the parameters that are set by those regulations that Pia mentioned. So the government's selection of a contractor in these instances is generally based on this uniform and competitive process that is consistent across the board in many ways, and that's using taxpayer money. So a good illustration of these competing considerations are what are termed P3s, or public-private partnerships. At its core, this P3 is an alternative procurement method, which allows a public agency to partner with a private sector entity in order to leverage private resources and expertise and transfer the risk away from the public entity. Here in these P3 situations, financing comes from the private party, which means they have control over the day-to-day activities of the contract, but the public entity focuses on monitoring compliance with the government's contract objectives. These P3 contracts meet that legal and regulatory requirements while also considering public policy considerations, as well as the business practices of both the public entity as well as contractors.
Alex, did you just say P3? I don't know what that means.
So P3 is an acronym for the public-private partnerships.
Okay,
Yeah.
sorry if I missed that.
Yeah.
Easy way to get that.
Okay.
So, thank you for that, Al. Pia, what are some of the main areas of concentration in procurement when we start talking about really critical issues? Because again, we're slowly acclimating everybody out there that this isn't your usual regular contractual bidding process or RFP. There are lots of other issues in here. What are the things that really start to lay out, if I'm going to go fill out an RFP, a public RFP, what am I supposed to be looking for? And what do I have to watch out for?
Sure. So one of the biggest things that's going to happen with this service provider or product provider is they need to be double checking, triple checking that they will be able to get their component parts. Supply chain is real. It's still a problem. It's not as bad as it was. I live in Newport Beach, and we used to be able to see, like a train rail yard, all the container ships all the way down, and we are not close to the Port of Los Angeles. So, it was absolutely epic. And so you've got supply chain disruptions. There's also issues in the trucking industry. Anybody is fascinated about that, please reach out to me directly. What's going on in the trucking industry is really tremendous. And so you need to have a handle on supply chain, backup, alternative providers. And so with that also,
And now you got to be worried about cranes spying on you too.
Right? Exactly. And so it goes to your supplier relationship management and those close relationships. And I still tell all my folks, my sales folks, my relationship folks, old school, man, take people out for lunch, go to drinks. Like, we're not under contact restrictions anymore. And and so really make sure you know what's going on, and low level person to low level person, right? Because they may start talking out of school and, oh, we're having real problems with this, we're having real problems with that. So you can start looking around for someone else. It's not easy to jump from one person to another, right? Are you dealing with tool and die type things that have a lot of lead time? And so you really increase your chances when you can say, like, oh, you don't worry, you give it to us and we will be able to get all this stuff to you. Obviously, compliance, regulatory changes, demonstrate how dynamic you are, the great people you have. You're able to nimbly take care of all that stuff. The cost management is something that I referenced before, and you really want to be able to optimize those kinds of things, and be able to show, you're not trying to fleece or skim or all these other type things, which of course nobody means to do necessarily. And so you really, that the whole life cycle, you want to show that you're doing things in an efficient way with the right folks. There is the sustainability and ethical sourcing. I'm not putting too fine a point on that actually for right now. There's a lot going on out there, and I know part of our series is corporate board boot camp. I'm in a bunch of associations related to that, and there's a lot of pushback on ESG right now. So it is something to keep in mind. What I'm saying is a practical matter. I don't know how much that's going to differentiate you. So if you're going to put your eggs in some baskets, I'd only put a couple in there. The cracked ones can go in that basket.
Well, I hear that no one
yeah.
likes the word ESG, but they're going to keep on doing all those things in the background.
Correct.
Yeah. So,
But as a priority,
yeah,
right? Like ESG isn't going to help with cost effective most of the time. It is not going to help with your supply chain, right? All things being equal, it's ESG that's going to fall off, right? It's money and time. And so if your ESG doesn't help money and time, no one actually cares. There, I said it. Said it out loud. It's being recorded. So obviously technical integration, and I think that goes to confidentiality, cyber. Everybody loves technology, but you can't really cowboy it up, right? So with your technology, you really want to show, oh, we're using the best stuff, and look how secure they run a good ship. And then, yeah, strategic planning, forecasting, right? I really want to talk to everybody about the stuff that's going to move the needle. So be really careful with the pie in the sky. And I come from the VC world. So, right, we know people do it, but it only works so many times. So you're really better off with your projections, those types of things. Like, make sure that there's some meat in the sandwich. Oh my God, my analogies, like they're everywhere. I must be hungry. So yeah, that really is, these I think are the big things to really focus on that are going to move the needle for you. They are the critical issues.
okay. Thank you very much. So Dave's been sitting here quietly listening to all this, taking it all in. But he's been lying in wait, because this is one of the more important parts of the discussion. So we heard some general overview on policy considerations and how to approach this from Pia. What is one of the most significant policy considerations when you're developing a compliance framework to govern your public procurement efforts in a firm or a company?
Yeah, thanks for having me, Raphael and Financial Poise. And I apologize in advance if there are any technical difficulties, but we're having some issues. But I look at it when developing a compliance framework. I think it's important that government contractors keep in mind that ethics are heavily regulated, as they should be. You're dealing with government funds. And government contractors and businesses that do business, companies that do business with government contractors, need to be mindful of the enforcement of the False Claims Act. And there are state False Claims Act and federal False Claims Act, but for today, I'm just going to focus on the federal. Basically, the FCA, as I call it for short, prohibits contractors from knowingly submitting false claims to the government or making a false record to get a claim paid by the government. And not only—
Can you do like a hypothetical, like with real stuff? Like, what's an example of that?
Yeah, I can definitely give you an example, and that's coming up. But an example would be a government contractor contracts with the government to supply missiles. And there are certain requirements that the government has for these types of missiles. And let's say it's expensive to put in one of those requirements, and the contractor leaves out that part of the missile, and either, it doesn't meet the specifications for what the government contracted to have that missile produced. Well, if the company does that knowingly, then that would be a violation of the False Claims Act, and the money that was paid to them could be considered damages. And damages is a complicated question when it comes to government contracts and determining what those damages are. But that's one example, and I'll go through some additional examples.
Okay, one more follow-up to that, especially
Sure.
in that example. Like, can people ever go to jail for this stuff?
Yes, absolutely. And I think as I go on through my answering these questions, you'll see that there are civil and criminal penalties, which I'll touch on a little bit later in the questions. But as I was mentioning, the damages under the False Claims Act, you can get anywhere from 1 to 3 times the amount of the damages that you cause to the government, and almost $14,000 to $28,000 per claim in addition to that. So if you have multiple false claims under a particular contract, you can see how the damages calculations and penalties can get very high very quickly. The problem for a lot of contractors is that under the False Claims Act, you can act knowingly, which is the requirement, by acting with reckless disregard of the truth or falsity of the information. And that means that you acted with a form of gross negligence plus. And that's where a lot of, well-meaning and good-intentioned contractors run afoul of this particular statute. One of the most important parts of the FCA is its whistleblower provisions, which incentivize whistleblowers to come forward with information by awarding them a percentage of the government's recovery from those damages. And in fact, the majority of FCA cases arise from whistleblowers. So that's why it's critical for contractors to have a robust compliance program, I think, as Pia had mentioned, in which your employees actually buy into it and it's stress tested. And so the FCA it's a big stick that the government wields, and that's why it's the government's primary tool for committing fraud against the government.
On the whistleblower front, 2 questions.
Sure.
One, do they often get what I refer to as FU money from this stuff? Because I wonder if they're ever able to get another job.
It's certainly a calculation that whistleblowers need to consider whenever they're going to report, whenever they're going to go forward. Oftentimes, there are retaliation provisions in the False Claims Act, which, prohibit anyone from retaliating against anybody reporting that information. But, oftentimes whistleblowers can't go back into the government contracting industry once they've come out and they've been awarded money. So that's a calculation that they definitely have to go through.
To all of us, and you don't have to answer, but I'm going to put out there, would anyone on this call recommend to a loved one or a relative to be a whistleblower? Just think on that, and we'll see if anybody in the question wants to say it. I think we know where I'm going on it, but I always think whistleblowers are very interesting, and they're put in an unfortunate position most of the time.
That's exactly the case. But I think one of the questions you had asked are some types of FCA enforcement matters. In the government contracting world, you can have progress payment issues, the defective or non-conforming materials. That was the example of the missile. Misrepresentations, cost misrepresentations resulting in overcharges to the government. That would be another form. Defective pricing. If you retain overpayments for any particular reason, that is a potentially False Claims Act. Obviously, bid rigging and collusion are their own crimes, but they also implicate the False Claims Act. But I think for purposes of today, I wanted to focus on finally conflicts of interest. And that's another area of False Claims Act enforcement. And essentially, the government wants to make sure that they're awarding contracts, that people aren't awarding contracts to family members, and that contractors don't have conflicting roles. So the federal acquisition regulations require that contracting officers avoid, or contractors avoid or mitigate that problem. And organizational conflicts of interest can arise quite a bit.
Do you think my example of taking, your suppliers for golf or drinks or something, would that be a problem?
Oh, we'll get to that.
Well, and I'm not saying the government.
We'll get to that in
will.
a second. We'll
Okay,
get to that in a second, because it can be a problem. Habib, can I turn it over to Alexander?
Yeah,
to Alex?
absolutely. Absolutely.
Alex, Habib mentioned the FAR. Can you tell us what we often try to do in the series is we give you the reason why what we're going to talk about is important. We give you some of the main policy considerations that go behind that, and then we want to make sure that you understand where the meat and potatoes references, the laws, what governs it, and then we talked a little about the regulators after. Can you talk a little bit, like, where do we find the law that covers government procurement?
Yeah, absolutely. And so, as you mentioned, the FAR, or the Federal Acquisition Regulation, also known as the FAR, governs procurement of all federal government agency procurements. The FAR is extensive, thousands of pages, and the FAR governs all solicitations of federal agencies. It includes clauses. Its provisions govern what clauses will be included, meaning what requirements the government contractor has to meet, what requirements the government contractor has to pass through, down, or flow down to its subcontractors. And it brings in many of the requirements from all sorts of different regulatory aspects. So, for instance, you have executive orders that are implemented through the FAR. You have laws passed by Congress that are implemented through the FAR. Each year, the National Defense Authorization Act, or NDAA, typically has provisions related to certain defense contracts. A lot of times that will be implemented into the FAR, or the Defense Acquisition Supplement to the FAR, which is also commonly known as the DFARS. And I apologize in advance, government contracting has very, very many acronyms. So the DFARS is one of the most commonly used supplements, but it's important for contractors to know that when you're contracting with the federal government, each agency has its own supplement. So, we could go on just for an hour talking about the different supplements, but, to give you an idea, there's the DEER, which is for the Department of Energy. NASA has its own supplement. The Department of Veterans Affairs has its own supplement. There is a supplement for federal employee health programs. The list goes on and on. And so, in addition to this, basic regulatory body or resource, thank you, of the FAR, you have these additional supplements. And on top of that, you have state law. If you're doing a state procurement, there's the separate procurement codes for each state. And as I mentioned, there's all of these other areas of regulations that government contractors are subjected to. And many of those do end up in the FAR, but sometimes they don't, such as, executive orders or other laws passed by Congress.
And look, in some ways, it's a scary thing when someone talks about, oh, we're going to go do government contracts work, because they start hearing the acronyms, they start hearing all the complexity. Supposedly, they listen to us about how dangerous some of this stuff is, and but it is remarkably, once you figure out those key things, that there's a big, like, master volume called the FAR, and then you also have to check with whomever you're going to do business with to see if they have special rules and regulations. It makes it a lot easier. And I've had associates and lawyers that love that type of work. So they said, look, I don't need to necessarily know everything about NASA's, special book. I just need to go read it. I know where to find it, look at it, read it, and then I'm an expert, probably more so than anybody else who maybe, has been in it for a while that doesn't understand you have to go look in those in the special rules. All right, so let's wake everyone up after talking about acronyms and the federal acquisition regulations. Habib, what are some of the really hot button kind of compliance issues that have come up? I mean, we've had all kinds of interesting things happen over the last 7 or 8 years. Can you give us a couple of things to wake everybody up that's out there that we've seen in government procurement? It's become a real big issue.
Yeah, I think for me in my practice dealing with government contractors, it's the hot button challenge number one would be cybersecurity implementation. Last year we saw the rollout of the National Cybersecurity Strategy, and that outlined, the Biden administration's priorities for cybersecurity regulations and all the reporting requirements. And the strategy itself was released after the passing of the I want to make sure I get this right, Cyber Incident Reporting for Critical Infrastructure Act of 2022. And so essentially what used to be voluntary adoption of these cybersecurity risk management has now morphed into an era of broad and seemingly ever expanding oversight. There are new cybersecurity compliance rules and requirements from the Securities and Exchange Commission, the EPA, the FTC, the FCC, and TSA. I know we're trying to get away from 3-letter acronyms, but as well as the states of Texas and California. I mean, California and New York, excuse me. But, as the number of these new cyber attacks increases, there are new disclosure requirements from government agencies. And so I think there's this continued FCA risk there because the Department of Justice even has its Civil Cyber Fraud Initiative, which has been specifically targeting companies that either don't meet these cybersecurity compliance standards or fail to report breaches. So that's become a very hot button issue. And even with like emerging technologies such as advances in AI, the need for this cybersecurity compliance only increases. So that's my hot button issue.
That's great. That's great. Let's turn back to Pia. Let me ask you. Can you lay out in a kind of a brief sketch for us how the federal government, what kind of procedures does it use to award contracts?
Who you know?
Is that it?
Primarily, but they really want to see where am I going with this? So, they publicize their RFPs, they want to show transparency. So you want to make sure that your submission is robust and serves their interest, right? What's going to be shown in your response that's going to benefit that agency and things like that, right? Oh.
So but wait, before we can get to the strategy on this, like what if somebody comes in and says, hey,
got it,
we found out that there's a contract to put in, all of the Wi-Fi in downtown Seattle. They're just gonna go ahead and just blanket the entire city in Wi-Fi. What are some of the ways that the city of Seattle or the state of Washington might say, or both might say to you, and the feds too might sit there and say to you, here's how we're going to approach this? I mean, how does government usually kind of market out these contracts?
Okay, so there's a public process, of RFPs that's kind of similar to a solicitation of comments, right, on a regulation. So if you're in that industry, you need to know who your potential buyers are and make sure you're familiar with their particular mechanism of publicizing the RFP.
So an RFP is a request for a proposal.
Yes.
And it's basically where they'll even give you a cheat sheet. They'll say, hey, we're looking for this, and this, and then you try to match up with it. right? Okay.
Exactly. And that's why I say, on the strategy side, right? Think about how you're satisfying those requirements, right? And maybe you can sweeten it with some ESG, DEI, whatever the flavor of the moment is, to move yourself to the top of the list. So you will get something extremely specific. So don't skip anything. And then where you can, in a legitimate fashion, try to juice it a little bit to highlight why you should be chosen. Also be, right, everybody wants to low bid. I guess you needed to have some reconnaissance intel. Again, and it's impossible for me to not talk strategy, so if you want to kick it over to somebody else, find out if the agency that that you're submitting to basically always does low bid, right? Again, try to figure it out. Now, you hope that's not the case, right? That the agency's going to pick.
Yeah, and for folks out in the audience, so
Oh, yeah.
sometimes you've got folks that give you the terms and what they're looking for. And other times, really what they're looking for, though they may throw in a couple things. They may say, look, we want someone with a national presence. We may want to have somebody with, that's a small, medium-sized business, whatever it may be. But they may just say, we don't care about other, qualitative things. We're just looking on price. And so they'll focus on price. And when they focus on price, that's when maybe you have all kinds of techniques. Can you tell us about those, Pia? Like, for example, like when you seal a bid or when you almost like an auction process. But how do you, and that's where you can talk strategy too. But I don't think folks out there, they're out there listening to us to figure out like, what am I up against? What am I going to see possibly?
Right.
And so the first is kind of a contract by negotiation. The second really focuses on price, which is like a bids or sealed bid type of process. Why don't you talk about that real quick? And
Sure.
we can then...
So mostly how sealed bids work, right, is people put together all the requirements for the gig, and very often it's the agency wants it broken out, right? Sort of, again, it goes back to projections, right? What are these pieces going to cost? And so the government can see if it matches up with their expectations. One of the things that's a just practical piece on doing the low bid is it's almost universal that the main contractor, right, not the people who supply all the different pieces, who may or may not be subs, they might be vendors as well. When they are approaching a low bid strategy, they don't have anybody lined up for it. So if their bid gets accepted, then they are hitting the streets trying to kind of almost back in to the numbers they presented. So, that's why it's a difficult strategy to pull off. Some folks do want to do it as a loss leader, though, because, right, it's worth it to get that contract, and then you've got the street cred to get more, and you hope you're going to pick it up on the next few deals. So I think that is, one of the things that, always has to be super important in this process, in addition to all the parts that are, comprise integrity, and documentation and all those kind of things, because one hopes that, folks submitting bids and responding to requests for proposal to the government have their act together, right?
Right.
Hope they have a robust compliance, are behaving ethically. That's hard to teach.
Yeah. Alex, as a follow-up, do the procedures differ for state contracts and for PP3s?
Well, in the words of every lawyer ever, it depends. Both state contracts and public-private partnerships sometimes match the federal procurement solicitation RFP processes, and sometimes they don't. And without getting into nitty gritty details of each state, every single state, every single locality has its own procurement processes. It has its own procurement code that sometimes matches the FAR or the other agency's supplements and sometimes doesn't. So it's important, especially when looking to contract with a state or local entity, that you're reviewing or hiring outside counsel to review any sort of state-specific procurement code. For instance, if you're bidding on a contract with the state of California, you need to make sure you're complying with every single procurement regulation in California. And you might be bidding on the exact same work in Arizona, and yet you need to have completely different requirements set up internally to comply with that Arizona procurement.
And could I guess that maybe in California, the ESG and DEI stuff might be a little more important than it is other places? Maybe the P has been involved with? Yeah.
Absolutely. If you're a company who contracts with Arizona and Nevada and Texas regularly to do X type of work, and then all of a sudden you're bidding on a contract in California, you need, as the company, need to make sure that you're reading through all of the California specific procurement requirements to make sure you meet that.
The difference in trying to do work in Texas and let's say Pennsylvania, same thing. Pennsylvania is maybe a bluish red state. Maybe most of Texas is red, but that's a union versus non-union situation, right? Which is going to have all kinds of other implications. Yeah, so that's a very good observation. So let me ask you something now. A couple of technical terms that people will hear, right? Because folks need to get acclimated to this area. What does responsive and responsible mean when you're talking about government contracts?
Yeah, absolutely. So two very similar words that mean very different things in the context of government contracts. Something that I always like to use to remember is that responsive refers to bids or offers, while responsible is referring to the bidder or offerer. And so to break that down a little bit more, responsive means that the bid or offer itself complies with the material aspects of the solicitation. And P has referenced this a few times. You want to make sure that you are, the bid that you submit to the government entity meets every single requirement that they have asked for, or else you will be submitting a possibly not responsive bid. On the other side of things, responsible means that the bidder or offerer has adequate resources and record of performance, integrity, ethics, background qualifications that it needs in order to meet the requirements of the bid. And so looking at the term as a responsibility determination, contracting officers or the government agency in charge of the solicitation will oftentimes do a responsibility determination to make sure that the bidder itself is qualified to meet the contractual requirements of this solicitation.
That's thank you. That was very helpful, and I'm sure it was helpful to folks out in the audience. We're coming up on 15 minutes, so I'm going to ask our panelists to keep their questions kind of short and sharp, and then if we have some extra time, we'll have some fun discussing some of this. And again, I think we'll all agree that we have to be extremely interesting because we're making this fun. Pia, speaking of fun, if you don't win an award, are there ways to challenge the contracting process?
Yeah. So I've been involved in that situation. It had to do with, because there's so many different things, right? Habib talks about missiles. This was a particular situation where it was a collections agency applying for the Department of Education, right? To get the bids to collect people's student loans. And so we were denied, and it was a very big decision whether to protest, right? Because you've got to think about your next bid and your next bid. And is there going to be a change in the people deciding on those future bids? Now, I think for the most part, no. I think it's career bureaucrats, and I mean bureaucrat in the highest form. None of us could live in a society without bureaucrats. So for the most part, you've got the same people, I think, going over your bid. And so that goes to the protest side of the house. So yes, there are ways to do protests. There's multiple levels, right? And that will be all in the instructions as well. And that they usually send a little primer along when they reject you. You know, here are the steps you can take. You can do it with this one individual, then you can protest to the entire agency. Then sometimes it's an administrative law judge. So there's all sorts of different avenues for protesting. And you know, Government Accountability Office, Court of Federal Claims, there's all different ways, and I'm sure it's you know, mirrored in the states at some level. Again, strategy, you really got to think about it. Like, my question to clients, my CEOs is, who hates us? Right? And if that's the result, right? It's not, because sometimes you don't want to protest, you want to call. Like, what was the loser thing for us that we then need to put some resources in to make our next application better? But then there's also the like, oh, it was this guy. And so how much do we piss him off if our bid protest is successful, right? How much can he hurt us 10 ways worse the next time? Is there a chance with, you know, he's on his way out because he's going to go run for governor somewhere, right? It's not always those kind of things. So it is a very serious decision to decide if you want to be known as a troublemaker.
Well, and just to jump in, something else to consider is the cost too. Is the cost of protesting or fighting this out worth the cost of what you may win on the contract?
Right.
But what if the basis does it matter what the basis of the protest is? Because it seems to me that the ones that seem to be more successful are where there's a conflict or an interested party issue, as opposed to, I think my bid was better. So in other words, if it's a process or integrity of the process issue, that's something that might be a bigger issue. And maybe you don't go the protest route. Maybe you go instead the referral to whoever regulates that process route, and keep yourself out of it that way.
Raf, can you just do a hypothetical on that? Like,
I find out that the person who was bidding for it is the barred in 4 other states for fraud. I have a contract. I'm in DC bidding for something, and I find out that the person who won is barred from practice in Maryland, Virginia, and West Virginia for fraud.
And it's the wife of a Supreme Court justice. Come on, that was a good one.
Possibly. So Habib, let's go into penalties. What kind of penalties are available, both civil and criminal, for procurement violations?
Sorry, I was on mute. I'll try to be quick on this. I know we're running short on time. I like to think of penalties on an enforcement spectrum, where you have administrative penalties on the left, you have civil penalties in the middle, and then you've got criminal penalties on the far right. Administrative penalties can be anything that happens at the agency level. So it would be, potentially rescinding of a contract, or terminating an existing contract, but also suspension and debarment, which for government contractors can be a death knell if it's a company that relies heavily on its federal business. Moving over to the civil part of the spectrum, you have the False Claims Act, which I discussed earlier, and calculating those damages in contracts, which is can vary depending upon the type of contract you have and what you're supplying. But if it involved defective goods, for example, it's the difference between what the government paid for and what they received. So that those damages can be extremely high, in the hundreds of millions of dollars. So it's critical to keep the civil enforcement in mind. But finally, you've got the criminal enforcement.
Habib, before you get there, on the debarment,
Yes.
is that at the company level, or is there the analogous you know, you, Bob Smith, are not allowed to trade in securities anymore? Like,
That's
is it at the individual level too?
That's an excellent question. It can be both. It can be an individual who's debarred. It can be a company, and sometimes companies, will have an individual who's been debarred working for them, and they can't do that, or they have to have that person not be involved with whatever federal contract. So yeah, individuals get debarred all the time. Um, and that segues well into the criminal penalties, because oftentimes when you have criminal penalties that have been imposed as a result of some sort of willful conduct regarding regarding the government contract, they will almost always get debarred automatically. And so one of those types is similar to the False Claims Act on the civil side. There's a criminal False Claims Act. And again, this is for people who knew it was against the law and they did it anyway. It's willful conduct. You can be punished by up to 5 years of imprisonment and 250,000 in fines. There's also major contracts fraud, very similar, except if the contract's above $1 million, which most contracts are these days, the larger ones, the maximum sentence can be up to 10 years. And then there are other false statements in a government investigation are often levied. But those are there are some other criminal statutes which we can get into later, but I'll cover those in the next portion.
Well, let me ask you another question just to follow up on that. Explain to everybody what the revolving door is and how it affects and how it's tied up to all this too.
Yeah, so the revolving door is between public and private employment, and it's very common in the procurement world, particularly here in Washington, D.C., where I practice. You have a lot of federal agencies and a lot of public and private companies that do business with those federal offices in the area. So these employees who leave the federal government, who particularly if they've been involved in the procurement process or a procurement adjacent role, in the government, can be very valuable to companies because they know a lot of the people, they have contacts, and they know what the process is. And so whenever they leave government and join the private sector, there are particular statutes that govern what they can and cannot do. And the statute that covers this is Section 18 U.S.C. Section 207 for post-government employment restrictions, and then 18 U.S.C. 208, which governs what current government employees can do. And let's say if you're a contractor that does a lot of work for the Air Force and you hire a former technical expert from the Air Force to work in procurement for you. If that former Air Force employee participated personally and substantially on a particular contract or project or a matter, she would not be allowed to participate or work on that same contract or project as your employee. There are some exceptions, and it's possible to get a waiver, but those don't happen often. And similarly, if she was working on a contract or matter on behalf of the Air Force, and your company already obtained the contract or was bidding on the contract, she would have had to disclose to the Air Force that she was receiving a job offer from you, and either stop working on that particular contract or not take the job offer from you. So, the whole point of these restrictions is so government employees don't have a conflict of interest to do something that might not be in the government's best interest.
And we see that as lawyers, anyone who was a clerk for a federal judge like I was, or anyone who goes onto the bench or off the bench, or out of a public agency, has to deal with certain time periods.
Yeah.
And again, so we're cutting it close here. Pia, can you talk about procurement integrity and what that means? And you are on mute. And you're still on mute.
That was all part of my deliberate attempt to not share the paper shuffling. So,
I thought you were just trying to be mysterious.
well, that too, right? Even though I don't come off very mysterious, do I? I don't think that's not one of my things. So procurement integrity are going to be things that hopefully are common sense for a lot of people. So follow the rules. If this is supposed to be a confidential process, like perhaps as you had asked earlier about how do people know that there's an RFP happening? Well, sometimes it's because the government reaches out and says, this is a super confidential thing. We are asking you and 5 other companies to submit information. So if that's true, that it's super confidential, keep your mouth shut and take the precautions to not have leaks and things like that. Ethical conduct, that goes to what Habib was just talking about. And look at the regulations, like see what that is, right? What if a high-level executive got a DUI? What is that, right? Do you have to report that? How does any of that stuff work? So definitely look and see what that is, right? And then, if you got something worse in your midst, maybe, depending on how bad it is reputationally, sometimes you may want to just withdraw the bid. And then, excuse me, I'm sure there are also some top secret things. So, I got a buddy who works at the FBI, no working at home for him because you can only use a specific computer. There's no VPNs and things like that. So is that part of it? That you have to make sure that whatever information that you get from the government, so different than confidentiality, right? That you are maintaining the security of any types of information of following the rules. And then, in addition to the, shoplifting, whatever, robbing a bank, you have the corruption side of things. So, I guess try to see who's in your house. And a lot of times I think people have employees who think they're doing a solid for the company and they don't tell anybody. But of course it gets found out. Like, really, it's your responsibility as the general counsel. We can, not government contracting, but we can talk about the voluminous stuff the FTX GC didn't apparently know, right? It is your responsibility to know what's going on. And so don't shirk that because it'll come back to bite you.
Yeah, I can't comment about that since I represent the FTX GC. So let's move on to the issue of internal compliance requirements for government contractors. So Alex, Pia was talking a little bit about like the process and procurement integrity and making sure that there's no leak basically in the information, whether you're someone who's been in the government or outside of it, so that the process, so nobody gets an unfair advantage, right? What are some of the things that you can do in terms of internal compliance for government contracts?
Yeah, so I will keep this brief because we're pushing up on time. Written business code of ethics. Government contractors are subject to many requirements, and it's imperative on every company that's contracting with a government entity to make sure they know those requirements, like Pia was talking about. But something that you can do to protect yourself early and often is a written business code of ethics. In fact, since 2007, contractors performing certain federal government contracts actually are required to have a written business code of ethics, and exactly what's required in those codes of ethics depends on the contract. So it's important to know the requirements. It's important to know what contracts the code applies to. Does it flow down to your subcontractors? Do you have provisions in your subcontract agreements that make sure that your subcontractors are also complying with the provisions you have in your own code of ethics? And just making sure that that flows all the way down the supply chain to ensure that you're not going to get dinged for something that an employee is doing because they didn't know what they were required to do, or something your subcontractor is doing because they didn't know what they were required.
Well, and that goes to governance, right? So you have to be able to show to the government what are the requirements for people to know this? And is there a quiz? And how often do they have to take the quiz? And where do you keep the records of that? And so you
Yeah.
put it in for your vendor on a contract. What are you doing to make sure?
And that's even in cybersecurity issues or cyber breach issues, a lot of courts have been very, very hesitant to hold, say, officers and directors or management responsible for the cyber breaches because they happen so often, and they're almost unpreventable because criminals keep on changing the way they operate. However, there has been a foothold in places where you didn't watch your vendors and third parties that for which you're responsible for. So if you let a laptop go off with a vendor and you don't take care to make sure they're bonded, have same type of security concerns that you do, etc., and someone steals that laptop and it results in a breach, that type of thing is foreseeable and could have been prevented, as opposed to figuring out the next way that some
Yeah.
kid in the basement in the
Right.
former in Eastern Europe somewhere is creating havoc.
And I
So
think with respect to the directors being, kind of, I hope I have Latin right, res ipsa loquitur for a breach, right? Because it's a question of when, not if, on the breach. But what they can be gotten for is their response.
correct. All right, so we're going to end off with the last word from Habib. And this goes back to, can I bring, I'll give them equal billing, Krispy Kreme or Dunkin' Donuts. Can I bring that to a potential client? Can I bring coffee? Can I do any of those things and start talking about, like, can I show up, at NASA and invite some of my friends over to the commissary to get coffee and donuts or drinks after work or go bowling or any of these things and not be in trouble?
Yeah, the general rule is that anything that has monetary value is considered a gift, and government employees may not accept a gift from anyone who's giving that gift because of the employee's government position. But as with a lot of things, there are some exceptions. One of those exceptions happens to be coffee. Also, other refreshment items such as donuts. So I don't think you have to worry about the coffee and donuts. Where it starts to get tricky is when you've got lunch. What about lunch? Meals are actually considered gifts. And if the person buying your lunch is what we refer to as a prohibited source, someone who's doing business with you or wants to do business or is trying to get business out of you, then that meal is being offered for your position, then you can't accept it. What if the lunch is under $20? There's an exception for that. You can actually go to lunch with another person under that $20 exception, but you can only do it once. And there's a rule of $50 per year from one source. So yes, you can. There are some exceptions. It's tricky. You can accept gifts from friends and family, and there are some exceptions to that. But I think that it's important to try to have some clear-cut rules and guidance for your employees, particularly when dealing in the government contract space, because you have to be mindful. I hate getting back into criminal statutes, but bribery of a public official and gratuities under 18 Section 201 it's a real thing, as well as the Anti-Kickback Act of 1986 when it comes to government contractors. And there's a lot of enforcement that goes on. So it's critical to have that compliance program in place that gets tested.
And look, you may have a section chief, you may have somebody else who's around who has their own internal office restrictions, or there may be a restriction by government agency. You always have to go double check to make sure that some people found on it a lot more than others. Other people are like, bring on the Duncan, it's okay.
Yeah, it's important to consult with counsel and really, when you're hiring government employees, to have a robust onboarding process, where those post-employment restrictions are really hammered out.
All right, well, we're going to end off on that note. I appreciate everyone, the panelists, everyone that's out there. We could have gone on at much more detail, much more length, but I think we got enough information out there so you guys are able to intelligently discuss these issues with your partners and your clients. So this concludes our webinar. Thank you for joining us, and goodbye.
Thank you.